Ladies and gentlemen, thanks to Mr. Yuswari Ojemat for the opportunity. Let me introduce myself. My name is Julian Ferdinand from Class C with NIM 6211121176. In this time, I will give a speech about the government has new rules to protect migrant fishermen from Indonesia. But there are still three legal weaknesses. Early last month, the Indonesian government announced a one-stop shop system to regulate and contract migrant fishing crews. Conservative calculation from the International Labour Organization show that about 23,000 migrant fishing crews members are recruited annually. However, this figure could be higher because it does not include data from all government agencies that manage the recruitment process. The provincial minimum wage in the area is only around 1.8 million per month, a far cry from the $300 to $400 promised to migrant workers. However, in reality, migrant fishing crews often only receive $50 per month for the first 5 months on their tenure. The government hopes that the newly issued regulation can overcome this problem. Unfortunately, this regulation still has a number of legal issues that can hinder efforts to protect migrant fishing crews. The Ministry of Manpower wins the licensing authority currently. No one in the government environment knows how many migrant fishing crew members are recruited to work overseas. This makes it difficult for government efforts to monitor potential practice of torture and exploitation. This data confusion is the result of the struggle for licensing control between various government agencies, such as the Indonesian Migrant Workers Protection Agency, the Ministry of Transportation to Regional Trade Office, each of which wants to implement its own system. In the end, this new regulation explicitly gives control to one government agency, namely the Ministry of Manpower. 18 of 2017 concerning the protection of Indonesian migrant workers. That hasn't done for policy makers. Non-governmental organizations such as the Indonesian Migrant Workers Union and Migrant Care have long called for the need for regulation governing the issue of migrant fishing crew members. The government has now issued the regulation. Number 1. Terminology overlapping. Fishing boat crew or fishing sailors. The government regulation used a new legal term, migrant fishing boat crew, to refer to migrant fishing crew. This naming resembles the legal term fishing ship crew, which is contained in the derivative of rules number 18 of 2017 concerning the protection of migrant workers, which refers to these crew members as fishing sailors. This opened up opportunities for many agencies and the government to ignore their responsibilities to recruit migrant fishing crews. They may argue that change in recruitment practice did not apply due to the different terms, especially when business costs have the potential to swell. So far, cases of torture and exploitation of Indonesian migrant workers abroad have attracted a lot of public attention. Meanwhile, the inadequate working conditions for domestic workers, construction workers, and domestic fishers tend to be understandable. This integration may mean the government must apply the same standard of assistance to Indonesians working at home and abroad. 2. Potential for other licensing system for migrant fishery crew. The government regulation does not explicitly state that the new licensing system will be the only system that will apply in the future. The regulation states that the Ministry of Manpower will only recognize permits previously issued by the Ministry of Transportation or Kemenhub for a maximum of the next 2 years. During this period, permit holders had to adjust to new requirements, including a deposit of 1.5 billion Indonesia rupiah to cover the cost of financial responsibilities that they had not paid for their recruits. The newly issued regulations put an end to the 2013 regulation, which was used as the basis by the Ministry of Transportation to issue relay permits. However, the Ministry of Transportation has stated that the regulation is no longer valid as of July 7, 2021 and has replaced with the new regulation. 3. The need for special judges to resolve disputes. The new regulations include example of policy innovation that over time can improve compliance. The regulation requires the Industrial Relation Court to adjudicate dispute between ship crewing agents and migrant fishing crews regarding rights and obligations in placement agreements. Although several violations were reported to the government, only a few lawsuits eventually went to the district courts for civil proceedings through contract law. The policy provision that emerged in this new regulation aim to treat violation as special civil cases and require courts dealing with industrial relation disputes to handle these cases. A bigger role for the legal system case resolution through the Indonesian court system, although notoriously slow, is hoped to provide an answer to this problem. However, the Indonesian Migrant Workers Union has used the judicial system in various ways to advocate for certain cases. They also put pressure on the government to come up with better rules in favor of migrant workers over many agencies such as this recently issued law. Maybe that's all I will say. Sorry if there are any wrong words or spelling of words. Thank you for the time.